bailable offence and the word we use is shall. So you have to point out to the court that this is the bailable offence, and today we are going to deal with the provisions of the remand. Now the remand is very important topic so far as the criminal practice is concerned. So now we are going to deal with what is the remand, on what basis remand can be sought, at the time of remand which court has power to grant the remand, for how many days court can remand the accused persons, now what documents are required, what is to be perused by the court, what are the provisions regarding the remand, and what is the defense of the accused persons to not to grant the remand. So along with the other recent case law and other things we are going to deal with this. So first let us know what is the remand. There is no such a definition which is mentioned in the either CRPC evidence or IPC. What is the remand? So only two words are stated, that the police custody and the magistrate custody. So now I have already told you that when the FIR has been registered against the accused persons, particularly when the offence is non-bailable and cognizable. So in that case only, in that cases, because so far as the bailable offence is concerned, under section 436 of the CRPC, the accused has a right to get the bail, because the word which is mentioned that when accused has been produced before the magistrate or appear before the magistrate or before the IO, and he is ready to give a bail and furnish the surety, then the concerned court or IO has no option but to release the accused persons on the bail. So the word mentioned is a shall. So when accused person has been arrested in bailable cases and in non-bailable cases. So in bailable cases, accused can file application under section 430 of CRPC for bail. So in that case, even the police machinery has seek the remand of 7 days or 14 days. They may seek the remand, but due to this situation, as this is a bailable offence and the word we use is shall, so you have to point out to the court that this is the bailable offence, and as a bail there is a right of accused persons and accused is ready to furnish the surety. So in this case, court cannot allow remand. IO may seek the remand of custody of the police custody, but court, we have to, as a defense lawyer, you have to point out that this is the bailable case, and in this case court cannot pass the remand order particularly for the police custody. So it is a right. So now if it is a non-bailable offences, non-bailable offence are, you know, particular description of in the CRPC chart there is whether which section is bailable or non-bailable. So there is a schedule, it is called as schedule in the CRPC chapter 2 schedule 2. The offences which is mentioned in the schedule are non-bailable, right? Particularly there is a schedule annexed to the CRPC. Suppose for example in a IPC, for example there is a 307 in a chart, it has been mentioned bailable or non-bailable. So it is non-bailable, cognizable, triable by court of session. That has been enumerated in IPC. But when case belongs to the particularly for the special laws, that is other than the IPC. Suppose for example it is a POSCO case, section 8 and 12. Now Protection of Wildlife Act, PC, PNDT. Now these are the special law. If particularly in that act it has been mentioned that protection of wildlife, in this case if there is a section of 49 and for which punishment is provided, whatever may be, but if in this law it has been specifically mentioned that particular section is bailable, then it is to be treated as bailable. Or it has been stated that particular section is non-bailable, so in that case it has to be treated as non-bailable, because ordinary law always prevails over the Special special law is always prevails over the ordinary law. But suppose sometimes it has been mentioned that for example any of the law, suppose for example PCPNDT, Prenatal and Pre-Diagnostic Technique Act, PCPNDT Act. Suppose there is a one sections, particularly section 7 or 8. For that purpose, it has been stated that the punishment is up to 3 years, for example, but it were nowhere mentioned that whether it is bailable or non-bailable. So, in that circumstances, if punishment is not criteria for bailable or non-bailable, right? If, for example, in recently there are provisions relating Epidemic Diseases Act, right? So now there is a punishment of 6 months, some provisions. Criminal Amendment Act, recent Criminal Amendment Act section, that sections has been added by the police master. In that Criminal Amendment Act section, punishment is for only 6 months, but these sections are, in this case, in this law, it has been specifically stated that these sections are non-bailable. So only because the punishment is more, that we cannot say that this is the bailable or non-bailable. So punishment is not criteria. When the particular sections of particular act, it has been stated that in this law, these sections are non-bailable irrespective of punishment, then it has to be treated as non-bailable. So in Epidemic Disease Act, Criminal Amendment Act, so these are the non-bailable sections. So you have to suppose the remand, the accused has been produced before the remand, and other than the IPC, other sections of other act other than the IPC has been implicated. So you have to go through this provision whether these sections are bailable or non-bailable. If these sections are available, you have to point out to the court that all the sections are available, right? So, but when, for example, Copyright Act, you know, copyright. So in that case, it has been stated that particular sections for the punishment is up to 3 years, and left does not stated whether this sections is bailable or non-bailable. So what can you treat this section as bailable or non-bailable? Tell me, you understood that in IPC it has been specifically stated that which section is bailable or non-bailable, right? In a particular act like PCP, NDT and other acts, there has been specifically mentioned that this section is bailable or non-bailable. But when difficulty arises, in specifically, like for example, Copyright Act, only it has been mentioned that certain sections are punishable up to 3 years, more than 3 years. So in that case, difficulty arises. So in that case, how you apply your mind, and how can you convince the court, or how can court come to the conclusion that this is the bailable or non-bailable? Because when court accused has been produced before the court, first court has to take into consideration, what he has to take into consideration, whether it is bailable or non-bailable. He has to bifurcate. Unless he has bifurcated, he cannot go beyond for the police custody, because law says that when it is a non-bailable, then only in that cases court has a right to pass order of police custody. So what test court has to, suppose this accused has been produced book under Copyright Act, produced before the magistrate, and the certain sections are punishable up to 3 years, then what? Whether it is a bailable or non-bailable? Can anybody tell? Why?
Here this is mentioned less than this year.
Where it has been mentioned? So you understood all these provisions, but when there is a special law and in that special law it has not been specifically mentioned which section is bailable or non-bailable. So you have to consider the schedule 2nd of CRPC. In that schedule it has been mentioned that the offences which are more than 3 years, punishment provided for 3 years, treated as non-bailable. So it automatically says that the offences which are less provided, punishment provided less than 3 years are treated as bailable, right? But when this schedule 2nd come to play, this provisions of 2nd schedule are applicable only in those circumstances when in a particular sections of the particular act it has not been stated particularly whether bailable or non-bailable. Suppose for example Immediate Diseases Act and is Criminal Amendment Act, it has been stated that it is non-bailable. So in that case this schedule 2nd is not applicable. It is specifically stated. So this is always prevails over. This is ordinary law. In that case, what says that punishment is more than 3 years is to be treated as non-bailable. But here punishment is less than 3 years, up to 6 months, up to 1 year. But why this 2nd schedule is not applicable? Because this is the special law. Special law always prevails over the ordinary law CRPC, right? But in this case, for example, Copyright Act, it has been never stated that which section is bailable or non-bailable. So in that case, this chart comes to play in. So we have to rely on this schedule 2nd, and you have to argue that sir, copyright is special law. In that special law, it has not been stated whether this section is particularly bailable or non-bailable. So in that circumstances, we have to rely on the 2nd schedule, which says that if the punishment is not provided in the special law, 2nd schedule of the CRPC is applicable, and this schedule says that if punishment is provided for the 3 years, then it is to be treated as bailable. So in that circumstances, you cannot grant police custody, right? Understood everybody?
Yes.
So now, when accused has been produced, FIR, arrest, what is production of accused before judicial magistrate first class, and if there is a special law like POSCO, atrocity, anti-corruption, NDPS, Mcoca, MPID, UPA. So this law, special law, says that the only special court has power to take cognizance of the offence. So remand is accused is to be produced before that court. Particularly these courts are the session court, and as a power has been granted to this special court, sessions court, to try these cases and take the cognizance of the offence. So it is treated as special court. So when the accused has been booked under special court and there is a specific provision in the special court that such and such a cognizance has to be taken under this offence by the special court only, then in that case accused is to produce before the special court. Now the judicial magistrate has no right to take the cognizance. Means automatically it means what says that this court has no power to grant further PCR or MCR. सगळ्यात लास्टला लेक्चर कळलं. In ordinary law, it has been stated that such a cognizance is barred by the magistrate, then only special act. Otherwise, whether it is 302 triable by sessions or triable by magistrate, irrespective of that, if specifically no bar taking the cognizance, even in session triable cases, court first accused has to produce before the magistrate. Then the magistrate had power to take the cognizance, and the magistrates can grant police custody. Understood? So what happens if suppose the provisions of the POSCO has been enacted by the police machinery, and for example atrocity cases, atrocity invoked, provisions of atrocity has been invoked along with the certain IPC sections, for example 376 along with the POSCO. Now under 376 JMFC has a right to remand, has a power to remand. But this section has been invoked till police has produced before the magistrate, the accused has been produced to magistrate, and under these circumstances magistrate had passed the order of remand. So now whether this order is legal, illegal, what is the remedy for that?
Magistrate has not power.
Then what will be the effect of that order?
Make a illegal detention
By whom?
against police must be.
But the magistrate has passed the order. No? Police has nothing to do with that. Whether you have understood this question, understood or not? Not understood. Atrocity is special court, right? So power of remand always entrusted with the special court. The ordinary court like JMSC has no right to pass and remand. So passing the remand, taking the person in a custody is affected with the right to fundamental right to life and liberty. So that liberty cannot be curtailed without the procedure established by law. So what is the procedure here established by law? Only the special court has power to grant the remand. So IO has committed error and he has produced before the magistrate in respect of these sections of the atrocity act being invoked by the IO, booked under this section, and this accused has been brought before the magistrate, and magistrate again committed a mistake and he has remanded the accused person for custody of 4 days. So now after 4 days it has come to the knowledge to the magistrate and the IO that this court has no power. So in that circumstances to be, then what will be the effect of that order? Whether this order is illegal, detention is illegal, then the 4 days period has been already lapsed, particularly for the 15 days custody is necessary. Then what would be the effect that when during that custody the certain investigation has been carried out, certain weapons has been recovered, what will be effect of this investigation? And whether now 14 days has been lapsed, only 11 days has been remained, for the particular PC is concerned only 15 days remand is allowed. So what happens in these circumstances? Can you tell? Read it tomorrow and tell me. Now I will go to the next point. Keep this in your mind. असा प्रश्न कधी तुमच्या मनामध्ये आला, whether this point came in your mind? Never? Never? You are not thinking. So if you are not thinking, this point doesn't come to your mind. Thinking is very important so far as the criminal practice is concerned. Only after thinking you will develop your presence of mind, logic, inference. Law of practice is always depend upon the logical thinking. You have to draw the inferences. You have to apply your mind. You have to think in all the angles. So now in that circumstances, magistrate or the special court has power to grant police custody. If the IO seeks the custody, IO can seek the custody for only 15 days and magistrate can also pass the order of 15 days. Now after lapse of 15 days, only magistrate custody is there. Right? And I have already pointed out that कि magistrate can pass order of police custody for 2 days, after 2 days, 3 days MCR, again police custody, again magistrate custody, but after lapse of 15 days only magistrate custody. So during the first 15 days court can pass police custody, magistrate custody, police custody, magistrate custody. Right? It has been stated in Anupam Kulkarni versus State. Write down the citations. I have already told you that. So, if you are magistrate going to become the magistrate, certain case come across or certain cases come before you. So, now in this particular circumstances, what happened that the police arrested the accused persons now and brought this person before the magistrate, and they seek that they want to take the identification parade of the accused persons on the 1st of the January. The accused has been arrested on 1st January, produced before the magistrate, and they say that right to police custody is reserved. So, in that because TIP is to be taken during the magistrate custody only, that cannot be taken in the police custody, because law is very much clear that any police officer should not be interfere with the TIP. So, TIP is to be always taken in the magistrate custody. So, police take the ask for the court for magistrate custody of 4 days, right. So, during that period 4 days magistrate custody, the TIP has been conducted, and during that period once a magistrate custody has been taken place, then the accused has a right to apply for bail. Only after the magistrate custody the accused can apply for the bail. So, but this then in that circumstances magistrate or the special court shall not pass the order of the bail, because after they have reserved their right of police custody, and after 4th of the day, on the 4th of the day, 6 remand for the police custody. So, during that period remaining 4 days, remaining 11 days, right, for the first 15 days. So, for that purpose police can seek the custody till 11 days of the police custody, and court may grant till 11 days depending upon the progress of the investigation. Understood this? So, you cannot commit any error. Only because person has been taken in MCR, he has applied for the bail, then magistrate has to wait till 4th of the day whether the police are seeking the police custody or not, right. Understood? Only 13 minutes left. So, now again there is a special law like Mcoca, MCOCA. In that case, it has been stated that the 13 days PC. So, ordinary law says that only 15 days PC can be granted, police custody is to be granted only for 15 days. But Mcoca says that police custody is to be granted for 30 days. So, maximum period for police custody is 30 days. So, this ordinary law does not prevails. This law always prevails. Suppose for example, certain sections 307 has been that A committed offence of 307 along with the XYZ. These are the 4 accused persons committed this 307 and they have been booked for 307. So, they have produced before the magistrate, magistrate seeks their time and 15 days police custody has been granted. Because now at this stage provisions of Mcoca has not been invoked, only 307 has been attracted. So, it is ordinary law IPC. So, in that circumstances only 15 days limit for the magistrate and the police. So, 15 days custody has been granted, they have taken in MCR, right. And in this case limit for filing of charge is 180 days. Ordinarily it is 90 days or 60 days depend upon the punishment. If punishment is less than 10 years, charge sheet is to be filed within the 16 days from the date of arrest, and 90 days if punishment is provided more than the 10 years. So, it is for But when the provisions of Mcoca has been invoked, in that circumstances 180 days period is limitation for the filing of charge sheet to IO, and police custody can be seek for 30 days. So now even the 13 days has been lapsed, right? Still accused persons are in magistrate's custody. But after the 13 days, the Mcoca has been sanctioned there, because there is sanction is required for the investigate the matter, and sanction, and the police has taken the custody of the accused persons from the jail. Now in which court they have to produce the accused person? Before Mcoca court, because when the Mcoca has been applied, ordinary court has no power to take a PCR, to grant the PCR. Only special court Mcoca has been power. So they have been produced before the Mcoca court. So now in that circumstances, whether the court can grant further PC, how many days, whether it is for 30 days, whether it is for the 15 days limit period, only remaining 15 days, because already 15 days PC has been granted. So during that period only 15 days is remain, so court can grant further 15 days PC maximum period. But I have already told you that so far as the Anupam Kulkarni versus state, when the accused has been produced and produced before the magistrate, arrest and produced before. So within that 15 days from the date of arrest, from the date of production, only suppose accused has been arrested, produced before the magistrate at the 1st of January, right? So after lapse of 15 days, that is 15th of January, whether court can grant the PC? No, because it has to be within the 15 days only. After that only MCR. So as per the Anupam Kulkarni versus state. But now here what happens that 30 days has been lapsed. After lapse of 13 days, accused has been produced before the magistrate. So in that circumstances, whether the Mcoca court has power to grant a further PC after the lapse of 30 days. So this is the special law, and there is a citation with that. कौन सा citation है? There is also citations of Bombay High Court. I will tell you later on. But in this case, the provisions of Mcoca, there is a special law. So even after lapse of 13 days, the police custody can be granted. It has been stated that till the conclusion of trial, before the judgment, the custody can be granted, can be 6. Even this 15 days has been lapsed, accused has been produced before the Mcoca court, they are in MCR, and judgment matter is kept for the judgment. But during that period, the IO come to the conclusion that certain new facts has been come to the knowledge of that IO. So remaining 15 days custody can be seek till the conclusion of trial. So the law which is stated in Anupam Kulkarni versus state is not applicable here. Any time remaining PC can be seek. Whether to grant the PC or not, it is always discretionary power of the court. Police has applied for the further 15 days, but it is a court who has to decide whether the grounds mentioned in the remand report are justified to grant the PC. So discretionary power of the court may grant or may reject, but the police has a right to apply for the remaining police custody till conclusion of trial. So here there are the provisions regarding the police custody, magistrate's custody, remand. So now again on the next day we will see what are the other provisions relating to the remand. So today we are concluding this chapter, and meet you